And the notion of environmental rule of law for all those who's working in the field of environment seems pretty obvious. That's what we're doing all the time. We're using the law in order to protect the environment, and it's a bit our daily bread. But actually, it does deserve a specific look. And beyond the people who are working in the field of environment, it does need also a stronger recognition. And in that sense, this report is a very, very important one. So we'll have a very interesting discussion today with very high-level speakers. And I'm very happy to open this discussion by giving the floor to Mr. Arnold Treuhuber, who is the regional director and the representative of the European office of UNEP. Arnold, the floor is yours. Thank you very much.
Thank you very much, Yves, and thank you all for joining this global launch of UNEP's second report on environmental rule of law. Let me also show the report again. And the report is entitled Tracking Progress and Charting Future Directions for Environmental Rule of Law. And at the outset, let me thank all of those who have contributed to the report. Numerous colleagues, leading authors, and institutions have lent their expertise to produce what is, as I have said, the second environmental rule of law report that UNEP has issued. And we're really proud of this second report. Today's event is intended to incentivize information sharing and in-depth discussions on environmental rule of law with some of the world's leading experts on the topic, to delve a little bit deeper into the findings of the second report and what they mean for environmental law and for environmental rule of law, what they mean for addressing the global environmental challenges the world faces. The concept of environmental rule of law is now a little bit over 10 years old. It was born, if I may say so, in 2013 in UNEP's Governing Council Decision 27/9. It was the first universal session of UNEP's Governing Council before the inauguration of the UN Environment Assembly that we now know. And the concept was born out of a recognition that the implementation of environmental law is still lagging behind, that violations of environmental law have serious consequences on the achievement of sustainable development, but they also, of course, have a very serious consequence for achieving environmental objectives. It has since been incorporated in subsequent resolutions, not least also in UNEP's Montevideo program on environmental law. And so it has, since 2013, been a very strong part of UNEP's mandate in environmental law generally. What is meant by environmental rule of law? I think that is quite simple to answer. Environmental rule of law is generally understood as applying the principles of the rule of law in an environmental context. I always underline that when this definition is made, there are perhaps two distinct aspects of environmental rule of law as compared to the general rule of law. Number one is what may be described as the precautionary approach, this element of scientific uncertainty. And the second aspect would be the intergenerational aspect, the rights of future generations that, in my mind, make environmental rule of law unique. Why is environmental rule of law important? This may seem obvious, but environmental rule of law has, I think, helped to shine a light on the importance of strong environmental laws and institutions. These are essential to achieving environmental goals and developing effective responses to pressing environmental crises. Laws provide the requirements, the standards, the procedures, and the rights necessary to achieve environmental objectives, and strong institutions are necessary to give force to those environmental laws and these environmental rights. And this aspect, I think, is even more important now that we have the universal recognition of the right to a clean, healthy, and sustainable environment. In addition to environmental benefits, environmental rule of law provides economic and social benefits by providing the protection of the natural environment. Environmental rule of law protects public health and economically valuable natural resources. By increasing transparency and reducing corruption, environmental rule of law can attract investment, support sustainable economic growth, and ensure that resulting benefits to nature are fairly shared. And this is an aspect, ladies and gentlemen, that I think we've tried to shine a light on even more in the second report, to also underline that environmental rule of law not only operates in a vacuum, but it is really a cross-cutting objective that needs many more stakeholders than just those that have been traditionally involved in environmental law. It needs to really bring together many other actors. I may even say it needs a whole of society approach to really deliver the benefits that are intended through all the laws and multilateral environmental agreements that have been adopted up until now. What happens in the absence of environmental rule of law? Well, it undermines good governance, and that again beyond the environmental sector. The effects of the absence of environmental rule of law can be felt way beyond just the environmental sector itself, because consistent, fair, and effective implementation of environmental law strengthens the perceived legitimacy of government action and builds public confidence in institutions, again, beyond just the environment sector itself. So despite the global proliferation of national laws and institutions over the past 50 years, the implementation and enforcement have lagged behind other sectors, resulting in mounting crisis of pollution, biodiversity loss, and climate change. And this implementation gap is still visible. I think that's what the second report also shows. So it needs increased efforts to close this implementation gap with extreme urgency to avoid dire consequences of environmental problems. Without going too deep into the findings in my introductory remarks, what are some of the key highlights of the second report? The second report again underlines that effective legal frameworks and capable institutions are the foundation of environmental rule of law, especially when they are unambiguous, informed by reliable data, fair and gender and culture sensitive considerations. The second report on environmental rule of law was drafted and produced, of course, also during the global pandemic. COVID-19 has impacted environmental rule of law, both positively and negatively. In many instances, it has helped to increase participation. In other instances, it had the exact opposite effect. And many countries, unfortunately, have rolled back environmental policies or enforcement in the interest of health, safety, and economic damage control. This is something that I think the international community needs to monitor and really safeguard against, that we don't give up what we already have achieved. The report also shows that technology can revolutionize environmental policy making and enforcement. However, questions of transparency, bias, and privacy might undermine its effectiveness and jeopardize people's rights, therefore highlighting the need for broad public participation in its implementation. Civic engagement is, of course, another critical aspect of environmental rule of law, and it's very pleasing to see that a growing number of countries have enacted legislation on access to information, rights of public participation, and access to justice. Despite this progress, there is still, though, a need for greater need for stronger laws and policies to protect, especially environmental defenders, against arbitrary arrests, violence, and death. During and before COVID-19, especially racial and social justice movements and protests around the world have driven also the engagement on environmental justice issues across the world. At the same time, environmental groups have increasingly incorporated racial and social justice issues into their agenda. I think that finding is also reflective of the broadening importance of environmental rule of law. Rights in the field or as far as environmental rule of law is concerned, as I have already mentioned, are both a tool and a prerequisite. They can empower rights holders, provide access to redress of environmental harms and accountability for decision makers. And again, in this context, the recognition of the universal right to a clean, healthy, and sustainable environment has sparked a new interest in environmental rights in general, and I think also highlights the importance to make yet another step forward in terms of environmental rule of law. Because the implementation of these environmental rights is still uneven. Many countries continue to struggle with the inequitable access to both natural resources and justice. This is something where the report also clearly shows that the international community needs to make increased efforts to equip countries and stakeholders with the required tools to improve. Justice ultimately is, probably the ultimate outcome if environmental rule of law achieves its objectives, and therefore a well-functioning justice system is crucial. It can deter, of course, violations of environmental law, it can improve compliance, and it can create accountability with other branches of governments. And these trends that I have just outlined have, of course, also affected courts in recent years. The pandemic has affected courts in the way they do business, has accelerated the digitalization of judicial systems. Judicial action on climate change has grown. UNEP also produces a status report on climate litigation. And if you're familiar with that report, it clearly shows that climate litigation around the world is on the rise. Again, highlighting the need for functioning institutions to allow people to bring their claims before courts and have them heard appropriately. The nature and number of remedies as a result have also expanded significantly as the judicial system gets more familiar with environmental cases. When I used to go to law school, there was no such thing as an environmental law course. I think that is also improving around the world as a broader recognition of the importance of the issue. And due to the transboundary nature of many environmental issues, justices and judges are becoming also more open to granting remedies to plaintiffs who have suffered environmental damage caused by foreign entities domiciled within their jurisdiction. Again, that speaks to the broader accountability and increased efforts that are being made on that front. But ladies and gentlemen, this is just a rough sketch of the findings of the report. As I said, today's session is really intended to delve a little bit deeper into the second report, hear from renowned experts on the topic, and begin exchanging a little bit the experiences, lessons learned, and perhaps decide on some actions on the way forward, how this report can be used within your constituents to make a difference as far as environmental rule of law is concerned. In closing, I want to highlight that UNEP will continue working on this issue with all of you. UNEP will continue to provide support to governments, to institutions, to civil society, to the legal community and other key actors in the pursuit of, I believe, what is our common objective: to improve environmental rule of law and really make sure that environmental law delivers for people in the planet as we address the global environmental challenges. So with these few opening remarks, I wish all of us a very interesting session, and thank you again for joining this global launch event for the second Environmental Rule of Law report. Thank you very much.
Thank you so much, Arnold. This was really a very needed, very substantial introduction to this very important and thick report, but also a very complete one. So now we will have two panels to discuss the issues, first on the cross-cutting issues and afterwards on the more litigation or judiciary aspects that you've just mentioned. And we will start with Mrs. Lydia Slobodian from Georgetown University, who is joining us online. Lydia, I hope you're hearing us very well. And we look to hear you because you have a particularly experience in all of the cross-cutting issues which have just been mentioned and which are in the report. And we've said it is not just focusing on purely, narrowly environmental aspect, but precisely addresses how these environmental aspects are linked to the social issues which are pretty important for their development. So Lydia, thank you for being with us, and the floor is yours.
Thank you so much, and thank you, Arnold, for that lovely introduction to this report. So when we were developing this report, we wanted to do a few things. We wanted to capture the status, like a snapshot of what's happening in environmental rule of law. We wanted to look at trends, particularly comparing this report to the first report, and then try to project, like, where is environmental rule of law going in the next few years. And we also wanted to identify key issues, key themes of the moment that really represent what environmental rule of law is doing right now in this time that we're living in. We identified 4 of these cross-cutting themes, and some of them will sound familiar because they kept coming up through the chapters. So Arnold mentioned a few of them in his introduction. The first is the pandemic. We drafted this while we were living through the pandemic. The pandemic was a daily factor in our lives, but it also really showed impact on environmental rule of law. I'll just go through the 4 themes, and then I'll go a little bit more in depth into each of them. The second was technology, the role of emerging technology in implementing environmental rule of law and realizing environmental rule of law, even in developing laws. The third was this connection between movements for racial and social justice and environmental movements, and the connection between social justice and environmental justice. And the final one was climate change. And we went back and forth on including that as a cross-cutting theme, because, how do we take this one crisis of the triple crisis of all of the environmental crises we're facing and elevate this to the level? And we're not saying in this that climate change is the biggest threat or the most important threat, though it may be. What we're saying is that right now, in this time, we're seeing a lot of movement on environmental law around climate change, from the laws and institutions to the civic engagement to the rights to the justice. We're seeing just a slew of happenings in the climate change space, and that bears bringing out. If you go to the next slide. COVID-19 itself had an unprecedented social, economic, and health impact. It may have had a direct impact on the environment through, for example, a decrease in economic activity may have led to a global decrease in emissions of greenhouse gases, as well as a decrease in ocean noise. It may have also led to an increase in plastic pollution, such as single-use medical supplies. And the economic downturn may have led to desperation, particularly among the world's most vulnerable communities, which could have increased pressure on natural resources. COVID also worked with other threats to create a disproportionate health impact on certain communities through cumulative impacts. So communities that were already suffering from the health effects of other environmental threats, those environmental health effects were led to increased mortality rates related to COVID and increased health impacts from COVID. Go to the next slide. As Arnold mentioned, countries responded in different ways, and in some cases, the same country. Some countries adopted new laws that were intended to strengthen environmental rule of law in the face of the pandemic, while others relaxed regulations and enforcement. For example, social distancing rules may have made it harder or impractical for companies to meet some of their environmental reporting obligations, or for inspectors to reach firms to evaluate their environmental performance. In some cases, this was the same country that in one sector passed new laws strengthening environmental protections, and in the other may have relaxed laws or relaxed enforcement. COVID also affected civic engagement. It limited opportunities for in-person attendance at public hearings, in-person judicial adjudications. However, it also may have led to innovation in virtual engagement and judicial proceedings that in some ways can increase access to justice and increase civic engagement. And we're still able to use these tools going forward. If you go to the next slide. It's hard to talk about opportunities. We're still so close to the COVID disaster, to the huge toll of human life and human health that it represented. But there were we must see some opportunities coming out of this global catastrophe, in that it is an opportunity to learn and it is an opportunity to build back better. One big lesson is that an investment in environmental rule of law is an investment in health. Whether or not this pandemic was caused by something related to illegal wildlife trade may be uncertain, but it is certain that there is a link between environmental degradation and human health. We know that environmental degradation can increase incidence of zoonotic disease. We know that environmental degradation can create these cumulative factors that make a pandemic more serious. So we also have an opportunity at this point to take these into account and build more inclusive and accessible systems and processes using the innovative ideas that we had to create to survive the COVID pandemic and taking them forward as new best practices. Go to the next slide. The second cross-cutting theme is technology. There's been a huge surge in technology, not just the technology that's available, but also the ways we use this technology in environmental monitoring and enforcement. Earth observation and satellite imagery has been used to detect illegal activity, from deforestation to illegal mining. Machine learning and AI provide opportunities to process this monitoring and enforcement data. Whereas before we might have needed a human to review thousands and thousands of hours of audio recordings, for example. Now AI mechanisms can do that sort of work for us and allow much more precise and in some cases quasi-real-time enforcement data. We're seeing a use of technology in citizen engagement through, for example, citizen science, through the use of social media in organizing, through, as I mentioned, virtual civic engagement, virtual opportunities to access justice and to participate in rulemaking processes. There's also another side to this. We're seeing citizen engagement in monitoring and enforcement. We're seeing reliance on reporting of citizens for example, identifying rules violations like idling in the city, or littering, or pollution. Finally, we're seeing use of technology in drafting and interpreting law. And we mostly drafted this report prior to the explosion of AI tools like ChatGPT. But I think that has really confirmed some of our thoughts, which is that these new AI tools are being used by lawyers, potentially by lawmakers, to conduct legal research, to develop legal documents even. And I think we're also seeing some of the dangers of this. Go to the next slide. One of the dangers of over-reliance on technology is this idea of garbage in, garbage out. This is an idea in computing that what you put into your computing system, what you put into your AI or your algorithm, what you get out is only going to be as good as what you put in. This means that if you're introducing human biases, there is a danger of getting a biased system. If you're putting in incorrect or misleading information, or you're creating a situation where the computer system or the technology system may rely on incorrect or misleading information, you're also creating a danger. A second danger is the growing digital divide. If we're moving important civic engagement processes and justice processes online, those can increase access, but only for those who have a strong internet connection, which is not everyone in the world. It's not even everyone in the United States where I live. Privacy and rights concerns, particularly with the new observation technologies. And finally, there is a question of digital security and the potential for malicious use. Go to the next slide. The third cross-cutting theme is this connection between social justice and environmental justice. I think many of us struggled with the increasing salience of the issue of social and racial justice. In the midst of the pandemic, it took a lot to get people out of doors, and the racial justice issues and the social justice issues came to a head, became so salient that they became impossible to ignore, even in the midst of a global health crisis, such that people took to the street wearing masks. to protest absolute inhumane treatment on the basis of race. In the United States, this manifested as the Black Lives Matter movement, but similar movements were occurring around the world. At that time, the disproportionate environmental impacts on racial minorities and disadvantaged social groups were already a theme in these social justice movements. This includes things like cumulative impacts, or what have been called sacrifice zones. And we saw both the environmental community taking recognition of the social justice and racial justice impacts of environmental decision-making, and social justice groups, including Black Lives Matter, recognizing the importance of environmental factors and environmental justice. Similarly, we saw a growing global recognition of connection between environmental rights and human rights, and this manifests in things like recognition of the importance to defend the defenders, to protect the rights of environmental defenders, and connections between race and environmental enforcement. Go to the next. Social justice groups, environmental justice groups, recognize that vulnerable communities and racial and social minorities are not just victims, but they are leaders at the forefront of civic engagement and lawmaking in the environmental space. And we're seeing an increase in recognition of the importance of diversity and inclusion in environmental institutions, based on the idea that more diverse groups, more diverse perspectives will make better decisions. Not just decisions that are more representative of different groups, but decisions that are just better because they're able to bring in different views and different ways of thinking about problems. And we've seen women, Indigenous peoples, and racial minorities and youth really take the lead as environmental champions. Okay, next slide. Finally, climate change, as I said, we highlight as a theme, not to say that this is the most important threat we're facing, but to recognize that there has been just an explosion in awareness of the climate problem, including public awareness and awareness among policymakers, as well as an explosion in environmental rule of law related measures. For example, at least 34 countries had declared climate emergencies at the time the report was written. That may have gone up. There were over 2,300 climate change cases filed in 55 countries. Again, these numbers are going up, and this only represents the cases that we know about, that we've been able to collect, which is primarily cases at the national level. There have been many more cases filed at the subnational level, we're almost sure. These cases demonstrate a human rights approach to climate litigation and a connection to future generations and the current youth. And finally, the UN resolutions on climate change and human rights recognize the importance of this issue. I will end there because I am also eager to hear from the other speakers. Thank you.
Thank you so much, Lydia, and thank you to both of you, Arnold and Lydia, for this in-depth presentation of this very, very important report. So now we will turn to a number of comments and analysis. But before I do that, I just want to take this opportunity to give the full names of the drafters of the report. Usually we forget about that, and it is in the report, but it's written in a very small characters. So we just heard Lydia, one of the main author, and she was in a team with Karl Bruch, Andrzej Jędrzejewicz, Claudia Davids, Rose Lisa Esma Osorio, and Tumai Morombo. And I think it's very important when we see the importance of this report that their names be well known. And they were seconded by a number of other specific authors. So you can find all of that in the report. So now we've seen in the last presentation some of the cross-cutting issues that this report is presenting. And of course, that immediately triggers a number of reactions for those who are directly concerned. And I'm happy to turn now to Ana Maria Suarez Franco, who represents FIAN, the Food International Action Network, here in Geneva at the UN. Ana Maria, you're very much involved in these issues. You know very well also how many other organizations are involved in these issues. So we'll be very happy to hear your views about precisely this notion of civic engagement and what is being presented in this report. As for all of the other speakers, you have 5 minutes, and I'll be showing some hands once we get to these 5 minutes. Thank you very much. The floor is yours.
Thank you very much. First of all, I would like to thank to the organizers and also for this important report. I think it's a very vast work that gives many elements for our advocacy work from civil society. Of course, our role is also to do social control, to call the attention on possible gaps. And I would like to go through some elements that I would like to highlight that are in the report, but also other elements that could be taken into account for the upcoming report, if there is one, or which could be discussed in the follow-up. First of all, I would like to thank you for this holistic approach of the report. I think speaking about the triple planetary crisis is very important, even in identifying what civil society has criticized a lot, and this is the false solutions. So we have solutions that sometimes can help to overcome the impacts of climate change, but create intoxication or pollution of the planet or destroy biodiversity. And in this sense, the more holistic approach is very important. And maybe jumping to another topic already on the comments, of course, we have to recognize that the rule of law is very important, as you said in the introduction, but laws are also the result of politics everywhere. And we are in very difficult times where for civil society, the elaboration of laws is especially challenging in the context of corporate interference and corporate capture. This is the term we use. Some authorities at the UN have also used that. And in this sense, we give big weight to the way how the concept is analyzed and the sense that these laws have to be just. In the box 1.1, it's very clear, but also of the consideration of human rights as an important part of environmental governance as a key tool. The rights to information and the meaningful participation together with the principle of accountability are key to ensure that laws, environmental laws, are just. This should include especially also the marginalized groups and affected communities and representatives, including those of future generations. And on this, I want also to thank for the expansive part on the rights of future generations, recalling jurisprudence that has been adopted in very different countries and regions. Mainly here, just to call the attention on the Maastricht principles on the human rights of future generations, which were adopted last year in February and which are not mentioned in the report. These principles made the task to take the jurisprudence that is there, the different cosmovisions, and departing from that to extract different principles that show which are the obligations of the states, which are examples of violations also in the framework of the triple planetary crisis, and go very well into the questions of corporate accountability, which is very relevant for civil society, not only social corporate responsibility, as well as include the relevance of the representation by marginalized groups when the rights of future generations are claimed or are defended. Also very relevant, and you mentioned that in the introduction, is the inter and intra-generational justice. And we think that we cannot think about future generations without taking into account both the precautionary principle, but also the principle of common but differentiated responsibilities and capabilities, which is more about the intra-generational justice. So in this sense, thank you very much for that. I cannot say all what I had, but I would like to focus also in the relevance to technology. I think The report is very positive on technology. Many good examples are given there. But even if the shortcomings of risks are mentioned, this could be mentioned or analyzed in a stronger way. I am just coming from Penang, from a meeting of different platforms working on financialization, and there is a big concern not only about the digital divide, which of course is problematic, but also on how technocentric approaches may be detrimental for the realization of human rights of the most excluded and marginalized people. We at FIAN have 4 reports on how digital technologies connected to financialization are causing, for example, digital land grabbing in different countries like Brazil, India, Rwanda, Georgia, and others. So maybe this is a place where you could put an eye. CL has been very clear on the impacts on geoengineering, right? And in this sense, very important to take a look on the precautionary principle that has been mentioned, and always very useful to look on the right to science, right? It's here there is a point between the cross-cutting between technological approaches and policy, but technological approaches can also be very influenced by corporations with vested interests. And in this sense, the lines that the Special Rapporteur on Toxics give us on the right to science and citizen science can be very inspiring for the laws that are to be developed. Of course, it is very relevant to take into account that the technological developments are in the hands of private corporations. This is natural. I will finish now, but we need to begin rethinking the digital, and rethinking the digital means also looking into which are the regulatory needs of the digital technologies, also with regards to the environment. And beyond that, even to think if some of these digital technologies should be public commons. Many of the issues and tools that are mentioned in the report are so important that it would be interesting to know if this could be provided as public services, for example, to ensure that we have all the citizen engagement and monitoring, of course, taking into account that these digital services do not exclude more those who are already excluded. I will leave that. Thank you very much.
Thank you, Ana Maria. And that was very clear and very good examples. Let me turn now to Professor David Boyd. Professor, you are the Special Rapporteur on Human Rights and the Environment at the Human Rights Council, and more than once in the previous presentations, there have been clear references to the gain of by the recognition of the right to a healthy and sustainable environment that happened at the Human Rights Council and at the UNGA. You were one of the driving force, I would say, behind this recognition. How do you see the connections between the environmental rule of law and the right to a healthy and sustainable environment? Thank you. And 5.
Thanks very much, Yves. First of all, congratulations to the United Nations Environment Programme for an outstanding report. And my friends, unless we strengthen the environmental rule of law, we will not successfully tackle the planetary environmental crisis. It's that fundamental, and that's why this report is so important. You'll not be surprised that today I'm going to look at the environmental rule of law through the lens of the right to a clean, healthy, and sustainable environment, a right which is not only recognized by the Human Rights Council and the General Assembly, but is found in law in 161 of the 193 UN member states. And the right to a healthy environment, we know from decades of experience, includes a group of procedural elements, including access to information, public participation, and access to justice, as well as a group of substantive elements, including clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments where people can live, work, study, and play, healthy ecosystems and biodiversity, and of course, a safe, livable climate. And each of these elements of the right to a clean, healthy, and sustainable environment depends on the environmental rule of law. So, for example, if we take access to information, well, transparency is absolutely critical. I recently came across a case of an indigenous community in Thailand that woke up one morning to heavy machinery being moved into their community for a coal mine, which they were completely unaware of. obviously violating their right to a healthy environment. When you talk about public participation, this is absolutely fundamental, as Arnold said, that we have inclusive and comprehensive public participation in all climate and environmental decision making. The third substantive element is access to justice. And although we have 161 states that recognize this right, we still have dozens of states where there has never been a single case brought by people asserting their right to a healthy environment. Not because it hasn't been violated or abused by businesses, but because access to the judicial system is blocked by costs, lack of trained lawyers with environmental and human rights expertise, etc. Turning to the substantive elements, if we think about air quality, there are still dozens of states that do not have air quality standards. Well, how do you actually monitor and measure improvements in air quality if you lack that fundamental piece of the puzzle? When you think about water, there are states that do not have the resources, the personnel, or the expertise to test for contaminants in drinking water, such as heavy metals like lead or toxic substances like perfluorooctanoic acid or PFOA, this non-stick chemical that's in the drinking water of 80% of Americans. Turning to food, there have been many states making progress in phasing out highly hazardous pesticides, but how do we dispose of the existing stocks of those pesticides? That requires a degree of expertise and institutional capacity. What happens when we talk about a non-toxic environment? What happens when large businesses dump vast volumes of chemicals into our air, water, and soil? We need institutions with the capacity, the personnel, the resources, and the expertise to investigate, prosecute, and convict those environmental criminals. I mean, when you talk about climate change, it's just continues to shock me that over $1 trillion every year continues to flow from states to businesses in terms of subsidies for the use of fossil fuels during a climate emergency. There has to be some corruption involved. We also know that greenwashing by fossil fuel companies undermines climate action. And finally, biodiversity. We know, for example, in one of the most critical biodiversity areas of the world, the Amazon, that the states that have Amazon forest within their boundaries often lack the capacity to actually stop deforestation in those remote regions. So you can see from these examples across the whole spectrum of procedural and substantive elements of the right to a healthy environment that strengthening the environmental rule of law, strengthening institutions, strengthening laws, providing more resources and expertise to those government agencies, ensuring their independence, also having independent courts and tribunals, eradicating corruption. All of these things are important prerequisites to the full enjoyment of the right to a clean, healthy, and sustainable environment. Thank you.
Thank you very much, Professor Boyd. That was a very, very clear presentation and a clear statement of the links between this right and the environmental rule of law. So as it was said, civic engagement is one of the very important elements which is coming out of this report and showing some of the recent developments in the field of environmental rule of law. And civic engagements can lead to policies, but also when policies don't work, it leads also to litigation. And now in the second part of this discussion, we will turn more on the judiciary and the question of litigation, because of course that's where also, to a large extent, as we say, the rubber hits the road. And how best to talk about the judiciary then starting with somebody who is representing the Supreme Court of Appeal of South Africa. Justice Nabita Dambuza, I hope you are with us. Thank you very much. And we're looking forward to having your views on the role of the judiciary in the implementation of the environmental rule of law. Thank you for being with us, and the floor is yours.
Thank you very much. Yes, I very well am with you. Good morning, good afternoon, good evening, everybody. I propose to be giving a brief development overview of developments, specifically within the African continent over this period of this past 4 to 5 years with regard to environmental rule of law cases that we have seen coming through the courts in various states in within the African continent. But first, I would like to echo what Lydia has said, that we've seen also in the African continent quite a bit of movement in the climate change sphere. I could pick up 3 states whose climate change legislation, specific act, was passed during this period of the report. Kenya had a Climate Change Act of 2016, but during this period, it has been revised and amended. And it seems that the aim was to give guidance to implementation of carbon markets in anticipation of what's to come. Uganda as well passed its Climate Change Act in 2021. And from my country, South Africa, the National Climate Change Bill was passed in Parliament, was approved really in the General Assembly in October 2023. So it still has another hoop to pass in the other chamber of Parliament, whereafter we hope it will be signed into law. So there has been quite a bit of movement in that sphere. Turning to what has been coming through the courts, and Juliana, if you can share the citation of the cases that I'm going to be talking about. I just picked up 4 judgments that I thought I could just refer to as a show of what's been coming through the courts. The first one, it's Lido and others versus Republic of Cote d'Ivoire. It comes from the Court of Human Rights, Court of Human and People Rights. I chose this judgment because we haven't had one like it before. Firstly, in a court, in this court, it is the first time that this court has pronounced itself on such an important matter, and it has actually given orders that are quite bold, and we're looking forward to seeing what will become of the orders that the court has given. It is a case about the offloading of toxic waste in Abidjan. It starts from 2006 when this occurred off the coast of Abidjan. And this toxic waste was dumped in various sites around Abidjan, leading to death of 17 people, and thousands, hundreds of thousands more of people were affected, well, to various degrees, groundwater contamination and all. The court, in the first issue that had to be addressed by the court is its jurisdiction, given that the matter had been litigated in the domestic courts of the persons concerned, both the claimants and the perpetrators. But the court affirmed the conventions on human rights and the right to a healthy environment. It said specifically, it recognized that it does not have appellate jurisdiction to receive appeals from the domestic courts. But it said, this does not include us from examining relevant proceedings in the national courts in order to determine whether they are in accordance with the standards set out in the Charter of any human rights instruments ratified by the state concerned. In other words, it firmly upheld the conventions that the individual states had assented to, and asserted its own jurisdiction where human rights are concerned. And some of the orders that it gave include that the state, which is Ivory Coast, had to enact legislative reforms within a year to ban importation of dumping of toxic waste, because the claimants had wanted an undertaking from the perpetrators, which was a company called Transfigura, that this kind of thing will not happen again. And the court also ordered that the state should, in consultation with the victims, establish a compensation fund from the amounts that had been paid by this company, because this company had entered into an agreement with the state to absolve some of the officials, and only 2 were prosecuted. So the court said, on top of the money that was paid by the Transfigura company, the compensation fund should be drawn from those funds, and also an independent impartial investigation should be opened into the facts to establish the criminal and individual liability of the perpetrators. So that was quite a far-reaching judgment of the court. This judgment only came out in 2023, I think about October, but the case had been going on for quite a while. Another one comes from Seychelles. The next one comes from Seychelles, where the court affirmed the fundamental right to an environment that is safe. What had been raised by the government of Seychelles was that it is not obliged to clean up where there has been pollution by private entities, because the domestic legislation says it may choose to clean up, and where it hadn't, it could not be held to be obliged. However, the court said that piece of legislation, the may shall be interpreted as shall. The state shall take the necessary measures to deal with pollution that is pollution by private parties. The next judgment is from Kenya. It is also from late last year, I think about October, November, where a provisional interdict was granted against the government, which wanted to lift a ban on to lift a moratorium that had been placed on logging in 2018. The court, I think here, applied in its mind the precautionary approach. One thing that one doesn't actually see coming through as yet is an express interpretation of these principles of precaution. And however, in the reasoning of the court, it does come through that the court said in this one, for example, it issued a temporary interdict and then said a task team report should be filed in court, and then depending on what the task team had recommended, then the interdict could either be confirmed or the logging ban would be the upliftment of the logging ban could be upheld, which was by the president. With the South African ones, and I think the Kenyan ones as well, we've seen that the use of technology has opened the courts up to prospective litigants in far-flung areas, and it has served as an educational tool as well. Indeed, personal attendance in court, the conventional way of doing things, is the first prize. However, I think, especially in communities such as we have here, where resources are scarce, but you'll find that everyone has a phone, everyone has a TV, or almost. And people do take interest in matters that might affect them. One of the South African cases that received worldwide coverage, sustaining the Wild Coast and others versus the Minister of Mineral Resources, which related to an oil exploration seismic survey by Shell. And here, what was affirmed by the court was the right to participation, because the court found that the indigenous communities around the portion of the ocean where the survey was to take place were never consulted. What we are also seeing, again, from South Africa is the affirmation of the commitments that the government made at the COP26 in 2021. Yes, that was specifically mentioned in the Sustaining the Wild Coast case. And then the other two, Groundwork versus Minister of Forestry, and the Groundwork Trust versus Minister of Trustees of Environmental Affairs, relate to environmental authorizations to build more coal-fired and gas-fired power stations. This is going to be a huge talking point in the country, both politically and in the courts, because we're seeing a lot of these cases coming through as we are confronted with energy shortages and the push by government to use some of the resources that are available, such as coal and gas. I think I'll stop there for now.
Justice Nabita Dambuza, thank you so much for presenting these cases from your own country and also from the African Court of Human and People's Rights. Unfortunately, we don't quote enough this court, so it's very, very important that we hear about these cases here in Geneva and that we take them into consideration. And I think it shows very, very well how much the human rights system is really part of the environmental rule of law. So now let's turn also to the situation in the Pacific. We have mentioned more than once here the question of climate change, and we know how much small island states in the Pacific are particularly affected, and we have the privilege to have with us Her Excellency Toleafo Nela Tavita Levi. I hope I'm pronouncing it correct. Thank you very much, Excellency. So we're very happy to have the views of the Pacific Islands and the small island states. The floor is yours, and thank you for being with us.
Thank you very much, Facilitator, Mr. Ladon, and apologies for my delayed arrival this morning. Thank you also, UNEP, and the organizers for organizing this event this morning. Talo Falava, and good morning. I congratulate UNEP for your second publication on the environmental rule of law. I also thank you for the opportunity for Samoa to come along, share a thing or two, and to be part of this exchange and to share some perspective from the experience of a small island developing state. I take note of the references in the report to Pacific SIDS, Nauru, Tuvalu, Fiji, and Samoa, and welcome very much examples and case studies in the report that we can draw upon for the benefit of learning and information sharing. Enshrined in the Constitution of Samoa, we are an independent state based on Christian principles and Samoan custom and traditions. Central to Samoa's customs and traditions is the Matai or chief system, which governs families, villages, and communities. Samoa's national Westminster system of governance recognizes the important role of the Matai system and decision-making at the village level, particularly for law and order. Today, there are designated government representatives in the village council whose role is to bridge communication between the government and the village and to enhance cooperation. So Samoa does very much recognize the integral role of customary law and practices and traditional knowledge in environmental protection and natural resource management. In the 80s, we recognized the important role of the village council that could play in the management of inshore fisheries. The 1988 Fisheries Act recognized fisheries village bylaws, which were set up by the village council. Monitoring and enforcement was undertaken at the village community level, such as sea patrols by canoe, routine use of watchmen to monitor illegal activities, moratorium periods on fishing, and fines set out by the village council, which we continue to see today in many communities, including that of the Pacific, and I'm sure all around the world. Many community-based environmental initiatives exist today, partnering with national police for enforcement. As the report refers, implementation challenges of environmental rule of law are not new and have been exacerbated by global crises such as the pandemic and technological advances to an extent. The government of Samoa remains committed to maintain a safe environment and to promote the sustainable economic use of our natural resources. As such, the pathway to the development of Samoa prioritizes having in place effective environmental protection and management frameworks through a cross-sectoral approach. There are at least 14 acts relating to the environment and administered across several ministries. Collaboration between ministries through the Ministry of Natural Resources and Environment is therefore essential to ensure sustainable management of the resources. Through ministry collaboration and consultation with the business community, the Waste Management Regulations 2018 enabled the ban of single-use plastic products as referenced in the report, furthering Samoa's commitment to protect the marine environment, the Pacific Ocean, and contribute to global efforts. The challenges relating to capacity remain, including environmental expert staff turnover. Hybrid meetings and workshops have enabled wider participation and engagement, but it's still not a substitute for in-person exchange and negotiations, which are costly. Samoa has a lands and titles court, which emphasizes the importance of customary land and chief titles in Samoa. There has been some conversations about the potential value of a specialized environment court that could focus on environmental offenses in a timely manner and help alleviate the backlog of court matters. I cannot say where that is placed in terms of priorities. This second report is useful and should inform countries in their efforts to develop and strengthen legislative frameworks and improve on international environmental rule of law. It's also important to continue to hold these discussions and exchanges to further build awareness, advance exchanges on environmental rule of law, and also to make the connections and the linkages between the environment, between human rights, and the realities that take place at home. In April last year, a high-level dialogue was held between the government of Samoa agencies, NHRI Samoa, civil and regional partners on advancing a human rights-based approach to climate action. This discussion included the right to a clean, healthy, and sustainable environment, connecting the Human Rights Council work here in Geneva to the work that's been undertaken in Samoa. I congratulate UNEP for the second report, and I thank you very much, Facilitator.
Thank you so much, Your Excellency, for this very clear presentation of how there is a need to articulate what is done at the international level and the local level. And this is really a very, very interesting example. So we will not leave the Pacific area, but now we will turn to another, I would say, bordering country of the Pacific, which is the Philippines. We have the privilege to have with us Her Excellency Carlos Soreta, who is a permanent representative of the Philippines to the UN and the other international organizations in Geneva. And the Philippines has quite an experience in environmental and climate litigation, both at home at the international level. And I know also that the Philippines is looking very closely at what is going on right now at the International Court of Justice and the preparation of an advisory opinion. Excellency, thank you very much for being with us. The floor is yours.
Thank you very much, Yves, and congratulations to UNEP. Environmental rule of law is very important to developing countries like ours and one that are most vulnerable to climate change. Whether we're doing transitioning, just transitions, we need the courts and judicial remedies to guide it and sometimes to push it forward, or whether it's stewardship over our natural resources, or whether we're dealing with bilateral or international financial institution in terms of loss and damage funds, they always look into us to see if our mechanisms, our frameworks, and of course our environmental rule of law is something that they can invest in. So it's very critical. Now, in terms of domestic legislation and litigation, we have a lot. We've over 30 years of Supreme Court doctrine on this. But the problem for us is climate change, and it's not solved by filing cases in victim countries. We are actually a carbon sink, so it's solved by filing cases in countries which cause the climate change. And we're hoping that reports like yours strengthen the environmental rule of law so that remedies are available in these countries. There have been some progress in filing civil cases domestically of nationals within our courts in the Netherlands and in the European Court of Human Rights. Because if nationals in their countries are able to file it against emitters, it benefits everyone around the world. So strengthening the rule of law in every other country is very important. But for countries like us and the Pacific Island states, where every time there's a super typhoon, we have to count how much shoreline is left, how many islands are left, and in between deluge, we get El Nino, where we have drought. So it's almost existential for us. We can't wait for the judicial remedies in every country around the world to work. So together with the Association of Island Developing States, we've been able to arrive at resolutions that allowed us to file requests for advisory opinions. The first one is in September in the International Tribunal Law of the Sea, where we appeared together with about 30 other countries. And coming up is the advisory opinion on international law and climate change in the ICJ. It's a bit risky. Clearly, there are positive norms do not exist, and what we're hoping to prove. So we're going to have to be a bit creative and interpret existing conventional norms as constituent instruments, as living documents, where the intent and object of the parties was to prevent certain harm, although climate change was not mentioned when this was being negotiated, but the intent is there. We're trying to get away from intertemporal rules, from Lotus principle that assumes that states cannot be bound unless they agree to. So we're trying to approach the advisory opinion in many, many different ways. The Philippines is using some creative arguments, particularly on the UN Charter. Climate change clearly was not in the context when the charter was being discussed, but the charter was intended to maintain the peace and security of mankind. And climate change is affecting the peace and security of mankind. Conflict can come out of competition for diminishing resources. Conflict can come from shifting maritime domains caused by loss of low water marks by territory. And of course, the climate change assails territorial integrity, which the Charter in Article 2, Paragraph 4 prevents. That a state cannot take territory away from another state or invade another state. But climate change is really worse because it does take territory away, and there's no defense against it. It negates the inherent right of self-defense. You can reclaim, but climate change continues. It's not like invading enemy that you can fight and defeat and expel from your territory. So these are the approaches that we're trying to present to the ICJ, which is a challenge because the ICJ increasingly from 1946 up, as multilateralism developed and more conventions were agreed on, where states came together, and now we have a plethora of positive law. In the same manner, the ICJ has shifted from largely customary norms to recognizing that states cannot be bound without consent to conventional law. So that's where we are. We thank you for your work on strengthening the rule of law in our country, and hopefully in the countries where they should be strengthened and where there are judicial remedies that the benefits of which could redound to everyone. But until that happens, we've taken a bit of a long shot in trying to get an advisory opinion from the International Court of Justice and the International Tribunal of the Sea. Thank you.
Thank you so much, Your Excellency, for this very interesting and very clear presentation of, and it's very nice to finish this review of the different elements of environmental rule of law on the challenges that needs to be met now by the environmental rule of law. A lot of the laws have been defined at a time where some of the issues we have to deal with were not on the table and not as clear as they are today. And definitely, if we want international law to be relevant, it has to evolve, and in order to be precisely relevant to the challenges we are meeting today. So this is really a very interesting element, and we look forward to see how that will be developed in the discussions and at the end with the advisory opinion of the International Court of Justice. So now we have a few minutes before concluding to have a number of exchange and reaction. And we'd like to turn to the room and also to the people who are following us online to see if there are any questions. And I see here in the room the first one. Thank you for opening this discussion. So I will give the floor to Ukraine for a first statement. And please, all of the other participants who would like to ask for the floor, raise your hands or raise your flags. And for those who are online, please put your questions in the chat or in the Q&A. I mean, follow the instructions. I don't see the screen, so please follow the instructions on the screen in order to raise your questions. I'm very happy to give the floor right now to Ukraine. Please.
Thank you so much, Mr. Moderator. So my name is Alexander Kapustin. I'm Deputy Permanent Representative of the Ukrainian mission here in Geneva. First and foremost, Ukraine would like to extend its sincere gratitude to organizers of this event and all the panelists for bringing attention to this critical topic, and of course, welcome the release of the respective second report on the environmental rule of law. But let me share also with you a little bit on the Ukrainian perspective on the topic. So my country is deeply familiar with the vitality of the environmental rule of law discourse, as it has been combating Russian aggression for the past 10 years, the war which is cruel and merciless to our environment. One of the most terrible cases is the breach of Kakhovka Dam, and we appreciate the efforts of the UNEP to issue the respective report on the case. But Russia's invasion of Ukraine resulted, among other things, in almost 3,600 cases of environmental damage that have already been recorded, with the Office of the Prosecutor General of Ukraine investigating nearly 280 cases of war crimes that have damaged the environment. We strive to achieve justice, which means bringing Russia as a state to account and receiving compensation, as well as bringing to justice those involved in crimes against the environment, both from the command and control staff and the executors. There is a huge amount of work ahead, and Ukraine is determined to be one of the first countries in the world to bring the aggressor to justice precisely for the damage caused to the environment. Ukraine's strong leadership in this area and our joint efforts may well change the way that the environment is viewed in its conflicts everywhere. Namely, UNEA 6 has successfully adopted by consensus the resolution on environmental assistance and recovery in areas affected by armed conflict, initiated by Ukraine. The resolution, we believe, will contribute to the improving UNEP's operational activities in assistance to governments overcoming the negative consequences of armed conflicts for the environment. We also welcome the efforts of the high-level working group on the environmental consequences of the war in Ukraine, comprising of the Ukrainian officials and international experts, giving life to the Environmental Compact for Ukraine on ensuring accountability and green reconstruction following the destruction of Russia's war on Ukraine. This document includes profound recommendations to the government of Ukraine, includes an international community on how to address this challenge, and may serve as a turning point that environmental damage in war was fully recognized, understood, and appropriately addressed. Ukraine is also working on the environmental declaration, a fundamental document aimed at creating truly effective mechanisms for the protection and restoration of the environment from the impact of wars or other conflicts, regardless of the continent. And we welcome support of all interested parties of this initiative. With this in line, the government of Ukraine calls upon the international community to support Ukraine's peace formula, in particular the part related to addressing Russia's coast ecocide, and to move forward together in three directions: to assess environmental damage from the war, to hold the aggressor accountable for environmental damage, and to contribute to the ecological restoration and agreed transition of the economy. To conclude, the best we can do now is to prove that we are not just declaring our values, including the environmental rule of law, but also ready to defend them, including through discussion of environmental rule of law in the areas affected by the armed conflicts. I thank you.
Thank you very much for your statement, and we all regret that these type of progress have to come after an aggression. So we definitely hear you very, very well. I know also I want to apologize Anna Maria from FIAN, who has to leave right now. Anna Maria, did you have just one small word you want to say before you join your next meeting?
Thank you. Thank you very much for the invitation. Courage with the dissemination of the report. The only thing I couldn't say in my short time was that we are missing peasants, fishers, pastoralists, and others living in rural areas in the report. And I think the words of the ambassador of Samoa on fishers were very clear. So maybe for the next one, we can connect to the UN Declaration on the Rights of Peasants. Thank you very much. Yeah, and good council session.
Thank you very much. I know there was also a question in the room. Please, the floor is yours.
Thank you very much, Mr. Moderator. Good morning, everyone. I'm Marina Janusz. I work for the UNSC Secretariat that services the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, which is known as the Aarhus Convention. And I would like to warmly congratulate our colleagues from the United Nations Environment Programme for the launch of this important report. And this report is particularly important this year when the Sustainable Development Goal 16 on peace, justice, and strong institutions undergoes in-depth review. And the goal has very specific targets on access to information, public participation in decision-making, and access to justice for all. And of course, many findings of the report are very important and relevant to the work of the Aarhus Convention. And I would like just to highlight maybe 3 areas of work that we hope will be then updated and reflected in the next report, progress report on the environmental rule of law. So the first priority area relates to the protection of the right of every person of present and future generations to live in a healthy environment. This right is embedded in the preamble and Article 1 of the Convention, and parties reiterated its strong commitment to empower people with this right. And of course, in the light of the recognition of this right by the United Nations General Assembly as a human right, this work will be strengthened and continued. The second area of work is related to protection of environmental defenders. This obligation was initially embedded in the Convention through the Article 3.8 and currently was strengthened with the rapid response mechanism established under the Convention. And the third area of work relates to the functioning of the Convention. The Convention is open for accession by any United Nations member state. So the Convention continues to provide a valuable platform for interested states, members of judiciary, environmental NGOs, and other stakeholders in these matters, and we look forward to continue our successful cooperation with the colleagues from United Nations Environment Programs and other partner organizations and all interested parties in advancing the implementation and application of the convention. Thank you very much.
Thank you for this complimentary information. And just for the sake of, for the understanding of everybody, when you're talking about the rapid response mechanisms, it refers to the creation of the mandate of a special rapporteur on environmental defenders under the Aarhus Convention. There is another question, and we will also then finish with a question that was online.
Yeah, thank you very much, Eve. So good morning, everyone. My name is Rafael Pangalangan. I'm from the Environment and Climate Change team of the OHCHR. And the mandate I support is the mandate on the nuclear legacy in the Marshall Islands, where we're applying a transitional justice framework to its impacts on an array of rights, one of which being is the right to a healthy environment. And having reviewed the contents of the environmental rule of law publication, and my congratulations to UNEP for this very interesting literature. I'm interested to know whether whether transitional justice was considered in the drafting of this resource, and whether it is conceived and how it is conceived to have a place in the right to a healthy environment advocacy. So, thank you.
Thank you very much for this question. We're coming at the end of this very, very interesting discussion, and I propose to proceed as the following. We still have also a question that I will read coming from the people online, and I will ask Lydia, as being one of the author of the report, to respond to the last question we've just heard about transitional justice, and the one that I will read. And then I propose that we have two final comments from the special rapporteur and from the representative of UNEP in Europe. So Lydia, you just heard the questions on transitional justice, but there's another one also that says the report mentions new development in international environmental law, such as rights of nature and ecocide law. Could you comment on what you see as the impact and significance of these developments on international environmental rule of law? So Lydia, I'll be very strict, just 2 minutes, one for each of the two questions. Thank you very much.
Okay, thank you. Transitional justice. No, we did not really consider transitional justice in the drafting of the report, but I have noted it as something to think about in the future and maybe incorporate in a future report. Ecocide and rights of nature and other international law developments. So first, rights of nature and ecocide are not necessarily international environmental law developments. And I think we heard from the colleague in Ukraine. Ukraine is one of the few countries in the world that has ecocide in its national criminal code already. So as environmental law concepts at both the national and the international level, I think these are very interesting for environmental rule of law, and I think they're very interesting for the future of environmental rule of law. I think they both provide mechanisms for furthering environmental protection and protection of human interests in the environmental context. I think rights of nature is very interesting because it has both a kind of ethical, moral component, and it has just a very practical component. When you talk about legal personhood for non-human species, I mean, this is just something very legal and practical, analogous to legal personhood for ships or corporations that lets us use the legal system in a more efficient and effective way. And I think that can be quite interesting for its potential. And then ecocide also, in bring different types of causes of action, I think could be very transformational in how we can use law to protect the environment.
Thank you very much for these answers. And so let me turn now to Professor Boyd, the Special Rapporteur on Human Rights and the Environment. Professor Boyd, I think just for everybody to know, you're presenting some of the last meetings as Special Rapporteur. We're looking forward to continue to working with you because that's for sure that you have brought so much to the field that we will continue to work with you in this area. But what are your words here at the conclusion of this discussion on the environmental rule of law?
Yeah, thanks, Eve. Terrific discussion. And I would just really encourage everyone to recognize that the best way to strengthen the environmental rule of law is through a human rights-based approach to all climate and environmental action. A human rights-based approach clarifies the obligations and responsibilities of states and businesses. It focuses our attention on those people who are currently being left furthest behind. It provides institutions and processes for accountability. It catalyzes accelerated action and ensures the mobilization of maximum available resources. So if we want to strengthen the environmental rule of law, our best path forward is a human rights-based approach. Thank you.
Thank you so much, and thank you also for all the work that you have done as Special Rapporteur. So now, let me turn as a concluding remark to you, Arnold. You gave a very interesting and in-depth presentation of the report and its importance at the opening of this meeting. We're at the end of the meeting. What is your takeaway now? The floor is yours. Thank you very much.
Thank you very much, Ivan. What a rich and engulfing discussion it has been. We've heard about the trends for environmental rule of law, which I think illustrate that environmental rule of law lives and breathes. It's not static. It increasingly incorporates societal considerations. It is increasingly visible nationally and internationally as a concept that merits greater attention. And so the tracking of progress, I think, is very, very important. We've heard of the importance of environmental rule of law for different stakeholders, for different ambitions also. We've heard from Ana Maria Suarez from FIAN on the importance for civil society. We've heard that we still have a little bit of a path to walk together to really make sure that civil society aspects are fully included and environmental rule of law really delivers for the whole of society. We've heard from Professor Boyd again that environmental rule of law is critical for the realization of the human right to a clean, healthy, and sustainable environment, and what an importance a human rights-based approach has in return also for making sure environmental rule of law is established and delivers. We've heard from the progress that is being made in the judiciary, across the judiciaries. We've heard from Justice Dambuza the progress that is being made on the African continent. Justice Dambuza is also a member of the Global Judicial Institute on the Environment, which is an institute by judges for judges to enable this information exchange across different judiciaries, which, I think we've concluded today is very important, that the different stakeholders have also the tools and resources to meaningfully engage. We spoke about the digital divide. We spoke about other barriers that still exist in terms of getting information, getting the right to participate really in practice, and also then have the right to access justice. We've heard from Ambassador Tavita Levi what the importance is for environmental rule of law for Samoa, what role the different actors also play in Samoa, what legislative initiatives are underway, which speaks again to environmental rule of law not being static. Governments are reacting, governments are, I think, coming to grips overall with the increasing importance of environmental rule of law. Again, seeing it more broadly, seeing it as a reflection of broader societal and economic priorities. We've heard from the ambassador of the Philippines how important the aspect of justice is for a country like the Philippines. And that, I think, was a good segue also to what has been mentioned in some of the questions that came later, or the statements that came later in the discussion, that there is an increasingly important intersection of looking at environmental rule of law at the national level, but also then at the international level. What are the justice aspects? What are the roles that international courts need to play going forward in terms of environmental rule of law? We've heard that, of course, conflict presents its own particular challenges to making environmental rule of law a reality for people and the planet. And on that point, let me just say that, the environment is affected by conflict way beyond the firing of the last bullet. And so, of course, it's increasingly important as we unfortunately face increasingly conflicts around the world that we pay attention to the protection of the environment during armed conflict. We've heard from Marina the advances that are being made in the field of the Aarhus Convention, speaking again to international legal frameworks that can provide an entry for various actors, and can also help to protect those who are on the front lines of environmental rule of law, the environmental defenders. Let me just say SDG 16 was mentioned by Marina as well. This week we have the Regional Forum on Sustainable Development here in Geneva. The stock taking on SDG 16, other SDGs, I think also brings further relevance to this report. We need to track progress. We need to monitor what different stakeholders are doing. We need to learn from each other. We need to look at best practices. Only through a dialogue like we had today can we really make progress and make sure that environmental rule of law continues to thrive in the years to come. And so with these few words, I want to thank you all again for this very, very interesting discussion. And I think it was Anna Maria who said bon courage. So I want to wish all of us bon courage as we develop environmental rule of law further and increase its importance for people in the planet. Thank you very much.
Thank you. Thank you very much, Arnold. It's my turn now also to express my thanks to all of the speakers for the quality of their contribution, and also extend my thanks to the all of the person attending in the room and online to this discussion. And as it was said, I think we are going away with a number of very good thoughts on how to implement better this so needed environmental rule of law. And final thanks to the whole team of the Geneva Environmental Network, thanks to who we are able to have these type of discussions. A lot of work is happening behind the screen, and it's always forgotten. So I'd like just to underline this very much. Thank you very much, and all the best to everybody.
Just very rapidly, you mentioned the regional forum. There is an online side event happening on Thursday on environmental rule of law and the role of access to justice in delivering on SDGs 16 and 13. The information is here on the screen for those who want to join online on Thursday at 8:30 a.m. Geneva time. Thank you.